what stage, for example, would theft translate itself to impeachment? Mere theft would not be impeachment. You take people to court one, Chief Magistrate's Court. At the point at which it becomes impeachment is where the magnitude of theft, the kind of harm that it occurs, result in demonstrable harm to society or to the people. For example, if one were to steal all the budget for free primary education, that is not theft, that is impeachment. Because it would mean that thousands and millions of Kenyan students would not go to school. So that magnitude, nature of the harm is an important issue in deciding impeachment. Alexander Hamilton would fall into this issue. He was involved in some affair, so the story goes. When he was involved in these affairs with somebody, there was some money he paid to that person from the public purse, and he was confronted with impeachment. He said he went to the Congress, to a committee of House of Representatives. He confessed, I had done this, I paid the husband to this woman in order for these people, for this thing to go away. When the committee listened, the committee decided that no impeachment proceedings would proceed because these appeared to be private wrongs with individual failure to obtain matters at personal benefit. They could not be able to say that Hamilton was threatening the US society or the US state, and he escaped from that impeachment. So that, my Lord, that distinction is key, because you've had very many submissions, a lot of submissions. Going to the issue, why would you take the deputy president for things that we have existing law that says that how those matters can be handled, and where the deputy president could actually have been prosecuted the following day, because here enjoys no immunity, there's nothing whatsoever that could have prevented it. So that the point, talking about the motion of Honorable Mutuse, what we are saying is that that motion did not meet the initial threshold that impeachment was supposed to serve in a constitutional democracy. This is to ensure that you protect society and you protect the state. It was never meant to make it easy to settle any political scores or any specific fight, fallout that had happened. That would be an abuse of the impeachment process. And therefore it is for these reasons that in our submissions, my lords, we say that out of the 11 articles of impeachment, I believe there are 11, it is only the first one that we believe would meet the test that over and over have been repeated in the US. And this is the fact that the one concerning shareholding, the one concerning discrimination in tribal appointments and all these kind of things. We say that one could meet the threshold of what a person may be impeached. But, my Lord, we hasten to add, and we shall demonstrate shortly, that it is not, given the provisions of the Kenyan Constitution, that and the evidence that we have put in our affidavits, that was not a crime that could have been committed by the Deputy President. But we are also saying, on the same facts, in an appropriate, good conscious member of Parliament could easily have preferred them against the President, even going by the provisions of the constitutions that were cited. We shall come to that issue shortly. So that, my Lord, the issue for purposes of ground number one of impeachment is that impeachment did not meet the basic threshold of harm to the state and harm to society. All those other were mere crimes, and we shall be a mockery of a country if we were to say that every other little violations of the criminal law or the laws of ethics or the law of any misconduct is a matter for impeachment. My Lord, on this point, it is important to mention that it is no little wonder that this matter is highly contested or it is divisive. In the matter, before I go to point 2, in the only impeachment that we had the advantage to watch bits of it, and we have read a lot about, of Bill Clinton in the US, my Lord, it arose from the Monica Lewinsky affair. It proceeded, it failed at the Senate during the trial. But what is important, my lords, and this is important, we bear this in mind as we decide this issue, that the overwhelming majority of Americans repeatedly were not of the opinion that as much as there was moral deficiency on the part of President Clinton, his affair with Monica Lewinsky was a private issue, matters of private morality, not an impeachable offense. This, as we said, as the Chief Justice of the case of Githunguri said, justice must be understandable to ordinary people. The wrongs that we seek to vindicate must be directly connected to them. That a specific serious harm has occurred, Parliament is setting out to punish somebody for that kind of violations of the law. Issue number 2. Issue number 2, we cover it at page 19 of the submissions, all the way to 21. It concerns the issue of whether the first petitioner was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 or 52 of the Constitutions. My lords, here we can do no better than to deal with a quick summary that we did it in paragraph 43. There are various issues, 6 issues why these requirements were not met. First, my lord, we point out is that the mover of the motion must act as an autonomous agent of the law rather than an attack dog of anyone in politics by invoking Article 151. We submit that the 9th petitioner, I believe Mutusa is the 9th petitioner, was not a free agent in the manner in which this motion was taken. Number 2 is that before the MP moves the motion of impeachment, he was enjoined to satisfy himself that there were grounds to believe that it fell within the article set out in 141. We have just demonstrated that no attempt was made to ensure that criteria was met. Number C is that the Speaker of the National Assembly was enjoined to satisfy himself that the motion complied with Article 145 before he could subject it to a vote of the National Assembly. The Speaker of the National Assembly, we have submitted, lacked the fairness, independence, and political neutrality to objectively determine this issue. I believe a case where I was largely involved and where the High Court made an order saying that the neutrality of the incumbent Speaker was questionable has already been cited. So we have authority on the basis of a decision of this court of a 3-judge bench that the neutrality of the Speaker of the National Assembly was an issue. But more importantly, the Speaker of the National Assembly, a motion is received, he says it satisfies the criteria. First thing is a reasoned statement or position ought to have been issued for the simple reason that as Speaker of the National Assembly, not everything must be processed. Before you say this should be voted upon, the issue of compliance with the constitutions is a business of the Speaker. That was not done. Issue number C is that for purposes of Article 144 and 145, he was supposed to ensure that the appropriate standing orders had been modified. That did not happen. And in view of Articles 73, 75, Members of Parliament were enjoined to objectively consider and vote on the motion in an objective, intelligent, and fair and conscionable manner. Mob justice treatment was unacceptable under the 2010 constitutions. I believe I've heard previous speakers saying that there was a degeneration of decency, just like Honorable Karanja had said, on how to conduct these proceedings, and for people actually to be able to show, like in the Senate, that we are really jurors. We are supposed to hear the argument and decide. We cannot act as accusers against the Speaker. That protection of the law did not happen. And we are saying the Senate was enjoined to appoint a special committee. I will come to that matter. And that the Senate did not discharge its functions in an independent and fair applications of the law. We shall also be coming to that matter. The point at this particular stage that we need to point out, and it is important we connect this with the Constitution. In the US, the Constitution is a little bit, just says House of Representatives will impeach. They don't give procedures, how these things are going to be done. Then they say the Senate is going to be to do the trials, and the Chief Justice will preside in case of the President. My Lord, there is no requirement under our law that the National Assembly, that before this matter is put to the vote, that there should be investigation, that there should be vetting, to be able to ensure that the matter that is coming up for impeachment has adequately, is the one that is actually meant for impeachment. That one is not fair. And the significance of that, my Lord, is this, that for purposes of impeachment, we have a procedure in which anything can actually go, anything that can go wrong can take place, and in this instance, all that could possibly go wrong actually went wrong. And this is why we shall be submitting to tie that with the Senate. That because there is no investigation that precedes impeachment, the Constitution procedure that provides for investigation is an absolute necessity in order to comply with the law and with the rights of a person being targeted for impeachment. In the US, my Lord, even in the absence of
ClickUp replaced like 5 different tools for me.
We had tasks in one app, docs in another, meetings somewhere else.
Investigation, the House of Representatives, in all instances, they do not go to a vote unless and until investigations have been carried out and what in Kenya we call substantiation has taken place. In Kenya, no substantiations takes place at the positions of impeachment. That it is important, therefore, when we shall be coming to the safeguard that is provided when it goes to the Senate. That safeguard, as we say, also failed, therefore giving to the conclusions that Articles 27, 152, and 50 of the Constitutions were violated. I'll be returning to those issues shortly. Issue number 3 is the important that we shall be doing with my learned colleague, Martin Kamwaro. And that is the issue of ground 1. Ground 1, where regarding Gachagua, the Honorable Deputy President was accused of insightful utterances and all those kind of things, and ethnic balkanization, and trying to go for a policy that would discriminate against members of certain communities. My Lord, what we have done, that is a very long part that occupies our submissions. And it goes all the way from page 21 to page 26. We have given a historical account that we shall shortly be able to demonstrate. We have reminded, my lords, that when you go to our constitutions, You find the right to culture. I believe Article 11 is recognized. The preamble to the Constitution recognizes that Kenyans are members of different ethnic communities, but the diversity is respected. The system of devolutions that we have is also supposed to ensure our ethnic, communal, and regional diversity is given constitutional protections in terms of governance, so that ethnicity alone is not a crime. It is recognized that we come from different communities. They have been increasing recently. They used to be 42 for a long time. I don't know whether they are now 45 or the number that they are. But my Lord, be that as it may, we have demonstrated in that outline that we have set out in those proceedings that from the word go, and here I have had the benefit to quote my learned teacher, Professor Yedhu Muigai, Senior Counsel, in an important article that he wrote for a book on ethnicity and democracy in Kenya. He pointed out a number of things that from way at independence, Kenya became independent as a country of many communities. To get the independence constitution in the first place, you had to have some ethnic compromise on issues of power and resources. He explains that during the years, the vice of tribalism would creep in on account of the actions of the president of the day, a culture that continues afterwards. So the point that when you read that article, that you understand Professor Muigai to be saying is that these issues of ethnicity, this issue of saying that there has been unfairness in resource allocation has been our reality since 1963. That's the conclusions you come to. We have also quoted a book, a chapter written by Professor Karuti Kanyinga. Professor Karuti Kanyinga comes even with tables and charts with figures, showing the manner of appointments to state office and resource allocations from 1963 to 2011. Now, again, Professor Kanyinga, also Karuti Kanyinga, makes the critical point that ethnicity has been the reality of our politics. And power, because, and he explains very well, that because of the nature in which we elect the president, you have a situations of coalitions of major ethnic groups. Those major ethnic groups, when now it comes to resource allocations, they always would play a major factor. Because everybody at the end of the day, after you have become president, you want to keep power. And to keep power, you need to do some horse trading. That has always been done with jobs and elsewhere. So what's the significance of all this? The significance of all these, and we have quoted the book of Professor Mamdani. He wrote it recently. The book known as Slow Poison, Idi Amin, Yoweri Museveni, and the making of the Ugandan state. In Slow Poison, Professor Mamdani in the preface explains that whereas belonging to an ethnic group simply connotes somebody in terms of language or in terms of culture, it defines your identity. It is only at that time when ethnicity is weaponized that it becomes tribalism. So that ethnicity and agitation for your ethnic group alone cannot be a crime. The crime happens when it is actually converted into tribalism that now leads into particularly people being excluded and disadvantaged being occasioned against certain groups. To do those disadvantages and elsewhere, you need to be Yoweri Museveni, you need to be Jomo Kenyatta, you need to be Moi, you need to be Uhuru Kenyatta or William Ruto. There is nowhere where all these kind of transformation in which this disadvantage have occurred have been perpetrated by a deputy or vice president, as we ordinarily call them, except in a few situations like Rwanda, where Kagame for 10 years was a real power in Rwanda. In all the other instances, my lords, these are the scenes that we say, presidential scenes in Africa. Even Professor Nwabweze has written about them. So then, my lord, what's the point that we are making? The point that we are making is that in ground number one, and there are figures, we have cited them in our affidavits, to demonstrate that it is actually, Kamaro will be speaking something about that when you actually go to the ethnic figures, even given by the Public Service Commissions, National Cohesion, the figures demonstrate that you have had ethnic disparity over the years and not just right now. So what's the point? The point, therefore, is this, that because those things occur and they are already documented in official public documents of even constitutional bodies, the question then must be asked, who is responsible for those statistics? Because if for purposes of a court of law, evidence is everything. If you can be able to connect that in a certain reality, let's take it 2022 up to 2024, you had this kind of discriminatory appointments and you have evidence to directly attribute them, for example, to the deputy president, it is all that you will need to prove that he is responsible and it becomes impeachable. But, my lords, to do that again, as we have said, you need power. And you need the Constitution saying you are appointing people, yet this is the result you came with. If it comes to budgeting, the question would still be the same. It would be able to be said, and here, ironically, it is Parliament that allocates resources under the Constitution, but that does not stop our MPs from going to State House to seek resources. It is that contradiction of 2010 Constitution. But, my lords, the issue, for purposes of allocation of resources, you will need to go to the budget and say, person A is responsible for this discrimination that happened. If you can prove that, I would be the first one to agree that is impeachable. On the basis of the evidence before the motion, it is our submissions. And I followed the cross-examination of Mutuse and his witnesses on this particular issue at the National Assembly. This did not connect. So that it is our submissions, my lords, that for purposes of ground number C, a very serious constitutional issue ended up being trivialized to an extent that as we speak today, the problem, and there were recent figures that were given by the Public Service Commission, the problem remains, but the country is supposed to be satisfied with an illusion that the person who caused this, we removed him from power. My lord, it is our submission that one of the reasons why the High Court is the guardian of the Constitution is to ensure that this kind of hypocrisy, political hypocrisy, is not permitted. I go to
Council,
the number 4.
you want to reorganize yourself? You have 25 minutes. 25?
I'm actually trying to skip very many things. I will see what I am able to do.
25.
Let's see how it goes. I hope, but we shall get there soon. Let me see the time. So, my lady, we go to the 4th issue. Whether the standing orders under which the first petitioner was impeached violated Article 152 of the Constitution. I think I heard the submissions being made on behalf of the first petitioners, and I've read the submissions by learned colleague Ndegu Wanjiru. And I think I'm satisfied. Time can better be used by adopting what they have said and by trying to adopt a bit of what I have seen. I'm sure Gachagua is going to say. I will only say a simple point on this particular issue. And
Вау! Какой огромный кусок золота упал! Шестерен...
Ground number E. Grounds number E deals with the issue of whether the Senate's failure to establish a special committee under Article 145(6) rendered the removal of the first petition as null and void. So what's the summary here? The summary here, Your Honors, is that under Article 145(6) of the Constitution, the Senate was required to appoint a special committee. Why is a special committee necessary? A special committee is necessary, in our understanding, because of the mandate that is given to the special committee by the Constitution. And I repeat, the Constitution, not the standing orders. The mandate of that special committee is to investigate the matter. In this case, the matter of the impeachment of Honorable Rigathi Gachagua. We have demonstrated in our submissions that the Senate actually did understand what was its obligation. There was a motion. The terms of the motion are set out in paragraph 78 of the submissions. That there was a motion for the establishment of a special committee to investigate the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya. Why, one may ask, was this not carried out? There is a standing order, or rather, I read it from the Hansard, because it lapsed, the motion lapsed. It could not get somebody to second it. A constitutional, Sifuna, who was to second it, said, can read the mood of the House. I decline to second it. Constitutional rights cannot be lost because a certain group of MPs thinks that it is within their discretion to decide how compliance is going to be effected. That our constitutional procedure depends on whether or not somebody would turn up to say that I'm seconding it. That will amount to making a mockery of constitutional democracy if it means anything in our country. There was no basis upon which that motion could lapse. There was no basis upon which it ultimately depended on seconding. It was a constitutional command that you have a special committee to investigate the matter. And why investigate the matter? For the simple reason, again, that in our country, even a chicken thief is entitled to the rights to protection of law, is entitled to due procedure. What do those due procedures require? Those due procedures requires, amongst other things, that when your neighbor goes and complains that you have stolen his chicken, he reports, and the OB is, you report it in the OB, somebody at the police station is tasked to investigate, you are called, come and do this and this and this, and then a police officer, ordinarily we call them investigating officer, would come and actually trying to find out the truth. Is it true that there was a chicken that was stolen? Is it true that this is a person who stole the chicken? Even a chicken thief has that right in Kenya. And that is what due process means. The point being, and as I said, that in Kenya, you process things in the National Assembly with zero investigation. It is why we are submitting the Constitution says you must investigate. And it says who investigates and how many members of the Senate. So that in our understanding of justice and due process, unless one can get away of saying Articles 27 and Article 50 and the due process as we understand it in very many decisions of this court, the High Court, the Court of Appeal, and the Supreme Court, what they say on due process and procedure. There was a vote in the Senate that was not preceded by the investigation demanded by the Constitution itself. In normal criminal courts every day, in my early years I used to do very many cases. Very good cases would be lost on account of the fact that there was no investigation. And I believe this matter, it is so important that recently, when there was some interviews to pick the successor of the good Justice Muhammad Ibrahim, I believe, one of the candidates, Court of Appeal Judge Francis Tuyot, is captured by the Star newspaper. This appears at paragraph 86 of our submissions, where he was being asked about these matters to do with investigation and why and how it leads to many cases being challenged. Let me quote the judge. I don't want to summarize in the wrong way. He said as follows: the court cannot fill the gaps left by the investigator. If the investigation is defective, the case must fall, because the burden of proof is always on the prosecution. We often see cases where the chain of custody is broken or where forensic evidence is not properly collected. These are not just mistakes. They are a pattern that suggests we need deeper institutional reform in our investigative agencies. It is better for a guilty person to go free than for a court to convict based on defective and hollow investigation. Our duty is to the law and the constitutions, not to public clamor. The pressure of time must not be used as an excuse for a shallow judgment. The public must see that even in those 14 days, the court applied its mind to the critical grievance brought by the petitioners. So that, my Lord, the learned appellate judge was saying of something, a basic requirement of our constitutions, that investigations of crimes is important, because it is through investigation that you are able to tell the truth from lies. It is through investigation that an opportunity is accorded to the accused to point out that, consider this evidence, it does not show that I was guilty. So that your lordship's confronted with a situation where a constitution has said and has provided for a mechanism to ensure there is investigation. The Senate acts as if this is a matter of political discretion. You should be scandalized. The conscience of the court should object to this. And that objections must result that this thing has to die. Justice was not done. Justice was not done in the manner of impartial justice required in a constitutional democracy. I need to explain this further. My Lord, there was this important case of Kinoti and others versus Chief Magistrate's Court, a decision of Judge Mrima. Kinoti, I must say, is my partner in my law firm. And this case is important for a couple of reasons. It's a long judgment when you read it. But I quote these decisions from paragraph 87 to 88. for three major reasons. The first issue is that it cites several decisions that underscores the necessity of investigation as part of the procedure of administration of justice, particularly in all kinds of justice. Because even before a normal tribunal, there must be fair administration of justice. Because unless you want to have a case of Jesus Christ of Nazareth, if one were to be confronted by a situation where a court system doesn't care whether the allegations are true or not, then that would not be.
If you don't have a website for your business, it might as well be invisible. Hosting Your AI helps you launch your website in an afternoon. Just describe your vision and instantly receive the first version. Then personalize it by adjusting the visuals and the text. Save weeks and
Live alone a constitutional democracy. So that it is those investigations that you care about the truth. Caring about the truth is what can be able to validate our commitment to do justice. So that, my Lord, what we are saying is this. Truth became discretional before the Senate. Truth cannot be discretional before the High Court, because its full name is the High Court of Justice. We go to an important decision that was decided very many years ago. I believe it was in the year 2003, and that is the celebrated case of Juma and others versus Attorney General. This is a case, even when you go to committee, remandees knows it. They know the right to be availed statements and the evidence of the prosecution. This decision is important for that reason. It is later on find its better expression in Article 50 of the Constitution. But to the credit of the High Court, that very important decision was made when we did not have a good constitution like we have today. And these decisions, my Lord, was saying an important, crucial issue. He says that about the elementary system of justice is one that is justice that is based on investigation, a caring for the truth. What actually happened? Is this man guilty, as the people demanding his blood are saying? That must be the concern of the High Court. It ought to have been the concern of the Senate. Tragically, it was not. Remedy must now come to ensure that is done. And the importance of that decision of Juma, why I'm quoting it today, is that it refers, I believe it was by Judge Kuloba, Justice Mpogoli Msaga. It talked about the value of the adversary justice system and what it connotes. You do not read anywhere in our Constitution any description what the adversary system of justice is, but you see features of it embodied in our constitutions. My Lord, the adversary justice system is a procedure in which truth must be founded on those who say this man is guilty have an opportunity to say their piece. Those people who are saying this man is not guilty must have also the opportunity to say that he's not guilty. And at the end of the day, the judge, listening to the partisan speeches, to the partisan position of presentation of evidence, makes a decision on the basis of interrogation of facts and evidence, on the basis of a determinations to inquire into the truth, so that it is a commitment to seek justice through a certain methodology. It is our submissions, my Lord, that justice before the Senate necessarily had to fail, not only because there was no modification, but when senators decided This is a matter of discretion. You cannot. Many cases, like we've read from the learned judges of the Court of Appeal, many cases fail because investigations were defective. The case before you is a case of no investigation. My Lord, I repeat that. Because if we were to have, under the 2010 Constitution, a situation whereby there is a judgment of the High Court saying that justice done with zero investigation, ordered by the Constitution, is okay, one would wonder, why was the fight about? Why did we need to have a new constitution? My Lord, I am absolutely sure that we shall not reach there, and that is why we have tried to be able to demonstrate that that is indeed the case. My Lord, it is also important that we speak about something about the Senate and the structure of impeachment proceedings. My Lord, in the US, that's where impeachment came from. Even here, there was a bit of that I saw. Those people who had the House managers, the people from the National Assembly, who had said they have impeached this man, were given an opportunity to present their case. There was also supposed to be a procedure where Gachagua and his team would also be given their piece. The senators, as understood in the US, and as we saw during the impeachment of President Clinton, are jurors. They make the decision. You listen to how the cases have been presented, how the defense has been made. Then in good conscience and in fidelity to the oath of office, you decide, is this man guilty or is not guilty? There was a tragic failure by the speakers, it appears, not to have properly guided the senators. It's for a good reason that lawyers are ordinary speakers in Kenya. It should count for something. It appears not to have counted in this matter. But what's the point that we are saying? In the US, before the Senate, when they say the judge, the Chief Justice, is going to preside over the impeachment of the president, it is because ultimately he is the custodian of justice, of fair procedure, to ensure that these politicians, before they vote, they have been guided with the evidence, fair hearing procedures have been availed to the parties, and everybody has ventilated their case. Now, before the Senate, we had this issue, and some of my learned colleagues have already argued. There is no time limitations. And it is illogical why there ought not to be time limitation. If somebody says, I need an hour or two to properly prepare my case or to defend myself, that ought to be given in the ordinary course of things. Before the Senate and before the National Assembly, we've had politicians, they have had difficulties in giving a fair opportunity for people to ventilate their cases, even when the consequences are very dire. In the US, it took a month. Justice Rehnquist presiding over the impeachment proceedings of Clinton. In the US, no provision is given. How much time do you take? The Kenyan constitutions, when you go to the latter part of the constitution after the report has been submitted, there is no timelines that are given. It's an opportunity that is supposed to be given to now the full plenary and to both sides to be able to present their case. So that, my Lord, if that did not happen, and there was an obsession with the time, you must take 1 hour, you must take 2 hours before an important issue could be resolved before the senators, that was where the tragedy of justice occurred in this matter. And that also, my lords, it must be connected to two important issues before I forget them. Under Article 145 of the Constitution, the President and the Deputy President, they have two rights of hearing, expressly set out. The right to be heard before the investigating committee, the special committee, and the right to be heard by the Senate, the plenary of the Senate. Those are two independent rights to be heard. None is a substitute for the other. Those two rights cannot be collapsed because they don't serve the same purpose. My lords, even in all our trials, even in criminal proceedings, and we have discovery in civil proceedings, you have two rights. When an accusation is made by the complainant, justice will not be done unless the police also called you to require you to give a statement, to give you a side of the story. That's the first right. This right, in our submissions, is a right that ought to have taken place before an investigator appointed by the Constitution, the special committee. The second right is a second right to be heard by the person who will make the decisions of guilt or innocence. That was supposed to be the senators. The senators did not, at the end of the day, of course, have to have a serious right to be heard. But the more important point that I need to point out at this stage is this, that, my lords, under the Constitution of Kenya, you cannot be an investigator, a complainant. Those three roles to some officers appointed by KRA. So that if in the normal course of things, the High Court protects ordinary people charged with regular offenses, that you cannot, your due process rights cannot be taken away. It is all the more important, my lord, that that also be accorded to the first petitioner, unless there is any good reason that, and there is a principle of law that says no man is too high or too low to be unworthy of the protection of our constitutions. My lords, I urge that fundamental failure of justice is inexcusable and can only lead to one decision. There was no proper vote for the impeachment of the first petitioner. That, of course, goes with the issue of saying, and now that is the next issue, on whether the first respondent, the first petitioner is a subject or is a victim of a political conspiracy. My lord, it is important to point out that, because this is where my clients are very much interested in, that under Article 75 of the Constitution, when a person has been removed from office, 75(3), that person is disqualified from holding any other political office. My lords, the first petitioner is interested and is holds the political office, is a politician, and politics is a transactions between leader and people, as it were. We are here because I represent members of his constituency. And because of that particular reason, it is why the petitioners I represent would be very careful about the prospect of the leader of that constituency being barred from contestations of the political office on account of an extremely tragic and defective impeachment. Why does this matter, and where is the entry point? My lord, we have Article 1 of the Constitution. Sovereignty vests in the people. We have Article 38 of the Constitution, the issues of political rights. The Supreme Court has said adopting a certain memorandum on standards of impeachment, basically saying that impeachment proceedings must be carried out in a manner that ensures those fights that should be resolved by the people through normal democratic elections are actually solved by the people. So that the right to form government is a right to govern together. That is what Ben Wabweze told us in very many books that most of us quote times without number. The right to get power is a right to govern together. We have annexed the Memorandum of Kenya Kwanza. We have annexed UDA. UDA itself was an alliance that all said what after getting power we were supposed to do together. There was a breach of that democratic contract. That is not just a breach between the first petitioner and the sixth respondent. It is also a breach between the constituency that expected certain representations by its consciously appointed or selected leaders would partake in the governance of the country. Your Lordships, this matters because elections matters in a democracy. But my Lord, the High Court, as a guardian of the constitutions, cannot countenance a situation that in 2027, when we shall be doing an elections, if I figure out that Paul Muite is a very popular leader and he should seek power together with me, in a democracy, the mandate you get from the people is that you will govern for 5 years with Paul Muite. But my Lord, if it turns out that Paul Muite gets you to get to the office, and then 2 years or 1 year down the line, you want to remove Paul Muite and replace him with another person, two obvious questions would have arisen. And that question is, why did we have to go to the elections? We go to the elections in order to get the political elite that will be responsible for our statecraft for 5 years. But it turns out, my lords, that there is any single person alone or in conspiracy with others who can be able to change the nature of the democratic mandate obtained through an election. That would be a grave violation of democracy as ordinarily understood, but more importantly, of constitutional democracy in our country, because the constitution of our country, I think the Article 3(2) says it is unlawful to establish government otherwise than in accordance with the constitutions. In Kenya, government is established pursuant to an elections. It is therefore, my Lord, our submissions that a scenario in which the very foundations of our democracy is contested, becomes disputed, that state of affairs cannot be permitted. Recently, in the case of Governor Guyo, a 3-judge decisions of the High Court explained, we have quoted it somewhere, explained at length that the nature of our constitutional democracy is that you must respect the people. The people appoints you in this party, gives you a mandate to govern with this manifesto. That must be respected. Because if it doesn't, democracy fails in the most fundamental sense, that it ceases to be a transaction where government, in the words of Abraham Lincoln, is a government of the people, for the people, and that is supposed to serve their purposes. So that, my lords, for purposes that happened, water under the bridge. The first petitioner said, I no longer want the office. That right must be respected. But what is important is this. Still on account of the same impeachment, if there can be no lawful government in my reading, in the reading of the petitioners I represent, between the impeachment of the first petitioner and the next general elections, it is important that the government that comes to office in Kenya in September 2027 will be a government established in accordance with the constitutions of Kenya. How do you get that government? That is the end point. How you get that government is to ensure power is contested by everybody eligible on account of the constitutions of Kenya, without limitations imposed politically in order to secure political advantages. The case of conflict management, the ICC case, what was it all about? William Ruto and Uhuru Kenyatta are having ICC charges. They are not eligible to vote. The High Court decided many things. Some of the three that are important, that I wish to highlight, that he decided are: number one, that the issue of who governs Kenya with a written constitution is a decision that belongs to the people. The people are the best suited to decide on that issue. Issue number two that you get from that decision is that, given the history of our Kenyan nation, we had situations, you had it in 1969, you invoke a rule of procedure to get all candidates of Jaramogi's party debarred from contesting office. You had a situations whereby you could say that the day of nominations are 2 hours. Then you abduct your opponent. Your opponent does not submit their papers. Those are the kind of things that, in retrospect, the High Court in that case was saying are not permitted under the constitutions. That Article 38, the right to seek public office and to be voted, mean exactly that, and must be respected and cannot be derogated without justification. Issue number three from that case was this. It was the fact that, and that was for TNA. TNA had nominated William Ruto and Uhuru Kenyatta for their ticket for that year. And I represented TNA in that case. The right for TNA and its members to have William Ruto and Uhuru Kenyatta contest the elections was upheld on the ground that politics means nothing if the leader that best expresses your political aspirations in politics can just be disqualified, can just end up not being a candidate. So they upheld that right and said, for that right to be taken away in Kenya, very onerous standards would be required. In the case before you, my Lord, that onerous standards would be this. I'm about to finish.
Please.
Yes. That onerous standards would be this, that we have actually confirmed that there was a good impeachment.
This is Out with the Old and
6th, 1988 and 1992. It is a parliament that got rid of Dr. Karanja from his office in the manner that was described properly. Now, we also have the 13th parliament. We have its record of impeachment. I thank the lawyers for parliament for giving us the full answered reports. You read them. If you are with foreigners, we have read impeachment proceedings in other countries. I wonder how proud one would be to say, these are parliament. But that's not the important point. The important point is this, and we have the head quote of Sifuna. Before somebody can be able to say that we do our job. We honor the constitutions. Constitution says parliament be independent. It says protect the interest of the people. We have on record in our headquarters Senator Sifuna saying that he had observed, he said that in an interview with Cyrus Jirongo. He said that he observed that when the issue of the reductions of money to counties was taken to the Senate, he found it odd that senators voted against their counties getting more money. Yet the Constitution says you are in Parliament to protect the interest of counties. My brother, friend Degwajiro, has shown and tabulated in his submissions what people are saying during the time when they ought this or the other one to be done. We had in June 2024 a scenario whereby there is a national clamor saying this budget is bad. But it had to take an invasion of Parliament for these same members of Parliament to change their mind and to turn around and say, oh, it was a bad bill. What's the point we are saying? The point we are saying is a simple one. Before you say a good impeachment was passed, one must take a verdict of some kind and say, what kind of parliament is this? If a parliament looks like the 6th parliament, and we know all that used to happen during its time, then that cannot be a good parliament that will decide matters of life and death in the good constitutions of Kenya, and that can very easily attract our constitutional order. The final point, so that Mr. Kamaru can say his bit, is this, that there is an important issue, that an important right. I don't know whether there is a smaller section than that, but I like Article 28 of the Constitutions, the right to human dignity. That right to human dignity is actually a very brief provision. It says every person has inherent dignity and the right to have that dignity respected and protected. What does that mean on a day-to-day nature of things? What that provision means, as applied in the context of this matter, would be to say that in a country that Article 24 says we should be civilized and we should respect fundamental rights, if somebody says, I'm sick, and can I be heard on another day? That unless there is a very serious and express and explicit prohibition by the law, in a civilized society, you would have honorable senators and speaker permitting such a person to be heard on another day. It is something all of us lawyers, we know every day. In fact, it is only a very few lawyers, one judge had to ask, counsel, can you object? Your friend has said he is sick. You want us to proceed when he's sick? It is one basic courtesy because it arises from human dignity. There is a decision a while back that, this is the last point, a decision of Daniel Ogwaka Manduku and versus DPP, a decision by Judge Ogola, that
work today is broken. Every day, people juggle so many different
decisions. When I read that decision, it didn't appear like the judge was convinced that the petition had been filed properly. But at the end of the day, I saw the judge giving anticipatory bond. And why did he give anticipatory bond in that circumstances? He premised that on the right to human dignity. He said as follows, I don't want to quote him wrong. The purpose of bond or bail is therefore meant to treat suspected offenders with some measure of dignity. This dignity should be accorded to every citizen or suspect. The petitioner here prays for a bond or bail pending unless that should that happen. Arrest in Kenya, this is the important part. Arrest in Kenya has become a public spectre. And I should think the prospect of being arrested is the most devastating emotional issue for the would-be suspected criminals, more so if they hold high office. In Kenya today, the public waits with bated breath whenever a senior public servant is rumored to be required for arrest. In a primitive society, very important, that would be the day when villagers met at a public square to witness public execution of public offenders. It, however, needs not be so. Every Kenyan should be arrested with dignity and be given a reasonable chance to apply for bail, either before or immediately upon arrest. Whilst at this, I found out that the theories of arrest against the petitioner are speculative, and the petitioner would still be given rights. At the end of the day, the important of the case is that that bond that was being requested was granted to avoid a situation where the right to human dignity would be violated. In this particular manner, at that time I was watching from television the proceedings before the Senate when Paul Muite applied for adjournment on account of sickness. That was not granted. I remember one of my daughters, I believe this was Sheba Waidera, asking, why was that right not given? I was angry. I told him, these senators are biased. That's the only answer I could give. After some reflections, I told her, I think when this matter, I am aware impeachment goes to the High Court. I think when this matter goes to the High Court, we shall tell the High Court that was wrong. Mr. Kamwaro.
Thank you. Thank you very much. How much time